Well, hello. Welcome, everybody. I am so glad that you are here for this very special presentation by Blazek Law Group. Today, we're going to be talking to special needs parents specifically, and we're going to be talking about time horizons that are very important from birth to age 18. Now, this is the first part of a three-part series where we're actually going to be covering the biggest milestones really that a special needs parent needs to be aware of. And I'm so excited to have our two associate attorneys here with me presenting today. You're going to hear from them in just a second. They're going to introduce themselves to you. But first, a little bit about us. So, you're hearing from Blazek Law Group today. We are a law firm that is in Omaha, Nebraska, although we practice all over the state of Nebraska. And we are specialized in guardianships and conservatorships. In fact, it's a really cool thing to say, but for the last 2 years, we've won Best of Omaha first place in guardianships and conservatorships. We're so proud of the work that we do, and we really feel that because we're so specialized, we can often add to maybe what a general practice attorney could provide in terms of guardianship and conservatorship. We'll talk a little bit more about that, but just know that our area of expertise is guardianship and conservatorship. That includes special needs planning, that includes elder care, that includes mental health powers of attorneys. It's all part of that umbrella. And again, we are so glad that you're here for this first session of our three-part series. Now, a little bit more about us. We have three attorneys here. I just mentioned two of them, Phil and Eric. I'm the managing attorney at Blazek Law Group. My name is Molly Blazek. We also have two law clerks that are graduating from law school in really a matter of days. They're going to be sitting for the bar this summer and hopefully joining the firm as associate attorneys in the fall after they get their results from that test. So keep them in your thoughts this summer. We also have a legal intern. She just graduated from UNO and she's going to be studying for the LSAT, which is the entrance exam for law school. So she's taking a gap year, studying up for the LSAT, taking the LSAT, and then we'll be going to law school very shortly. Lastly, we also have a very rockin' rock star client coordinator where if you call her, her name is Grace. She's the first person you talk to if you contact Blazek Law Group. She's tremendous. She can get you set up with the right attorney, take all of your questions, and get you coordinated in onboarding if you become a client of the firm. She can also give you all of the resources, much like the one that you're utilizing today, which is a free workshop. And we do tons of free workshops throughout the year. More on that later. A little bit about me specifically. Like I mentioned, my name is Molly Blazek. I've been an attorney for 15 years. That seems impossible. I don't feel old enough to have been an attorney for 15 years, but it is true. I graduated from Creighton Law School in 2010. And at this point in my career, I have been involved in over 600 guardianships and conservatorships in some way, shape, or form. Approached, consulted on, represented clients. I am a guardian and conservator myself. And that's really what is the heartbeat of the practice at Blazek Law Group. We have such personal relationships with the clients that we serve, the vulnerable adults that we protect, and in some way, shape, or form, it has touched all of us personally. And that is definitely true for me because of my experience serving as a guardian and conservator. So one of the highlights of my practice is not only being able to give legal advice to clients, but also give practical advice to parents and other guardians and other conservators because I don't only know the law side of things, but I'm also doing the same things that you are, trying to answer questions on behalf of the person that I'm serving, going to banks, talking to the Social Security Administration. I've been there, done that, not only as an attorney, but as a person who is trying to get information, answers, and advocate for a person that I'm serving. We are the creators of the Guardian Connect Now platform, which is a platform that's available online. It connects guardians and conservators and other Nebraska caregivers to free resources and paid resources about anything and everything touching guardianship and conservatorship. I'm also an author of the Nebraska Elder Law Handbook, which is a desk guide for lawyers. And in 2019, I was appointed to serve on the Supreme Court Commission for Guardianships and Conservatorships. I have been so blessed to be a part of that commission. And in fact, we have a commission meeting tomorrow. We meet twice a year. So if there are anything today on this presentation, if there's anything that you want me to raise at that meeting, put it in the chat and I will be happy to try and address it with the members of the commission tomorrow. So that's a little bit about me, and I'm going to let Eric Wasson introduce himself next.
Hi, everybody. Yeah, grateful to be here. What a great opportunity for everybody here. Just very briefly, I put this first because it's pretty new for me, but I'm a dad now. It's kind of weird to say that, but um, my wife and I, we had our daughter almost a month ago now, I guess, or 3 weeks ago now. And so, still adjusting to that, but what a joy and a privilege to be a parent. Um, I have joined this firm last year and um, had such a great impression of Molly and of this firm and um, you know my experience has met and exceeded that impression. So I've really enjoyed working here. Um, when I was in law school, I graduated with concentrations in wealth management and business planning, and so that was kind of my background going in. Though previous to that, when I was clerking, I got to dabble in guardianships, got to dabble in special needs planning, and now that I joined the firm, that's really kind of my focus is those two areas. But obviously, guardianship is the main focus here. Personally, I like to rock climb. I like to volunteer, and some of that's through my church, some of that's through opportunities that we have, whether it is workshops or events. For example, last year I was able to do a Spanish speaking event for guardians or people that are looking at guardianship over at Monroe Meyer. And so I'm just looking forward to doing even more events like that this next year.
Well, thanks so much, Eric. We are so glad that you are here. You're such an asset to the firm and asset to the clients who hire you to do all of their special needs planning and consult with you about guardianships and conservatorship. So again, congratulations on your baby girl, and we're glad that you're presenting today. Now, Phil, why don't you give the attendees a little bit of info about you?
Hi, everybody. My name is Phil Wasta. I am the father of two girls, one of whom we recently, after a long period of time, got her autism diagnosis. So I'm very familiar with special needs kids and, by having one of my own. I joined the firm here in February, but I have been a licensed attorney since 2012. My previous legal work was primarily focused on insurance defense, so I have entirely too much information and knowledge with dealing with insurance policies and insurance companies. In my free time, I have two huskies and I teach martial arts. So it's just a bit about me.
Very cool, Phil. And like Eric, we're so glad that you're here. We think you're a tremendous asset to the clients that you serve. And I think your insurance days have made you kind of a pit bull as a lawyer. So, very strong advocate. And we're glad that you're here. Okay, so I want to give you some upfront resources. I think this is really important. A lot of presenters wait till the very end to give you tangible resources. We don't want to do that. We want to give you these. And if you get nothing else out of this presentation, this is probably the most important slide for you to screenshot and get resources, because this is essentially what we offer guardians and conservators throughout the state of Nebraska. Each Thursday at noon on Zoom, we host a virtual guardianship clinic, and really anybody and everybody is invited to that. It really doesn't matter where you are in your guardianship journey. You can be trying to decide if guardianship is right for your loved one. You can have been a guardian for 30 years. You can be a service coordinator with the Department of Health and Human Services. Everybody is welcome. And it's a place that has become a support group and also a place to share information and resources. I know that even though I often am answering questions as an attorney on the clinic for people who attend, I learn just as much from the other people who are attending as a guardian and conservator myself. So that's something that's completely free. It's every Thursday at noon on Zoom. And at the bottom of this slide, I've given you a website, which is guardianconnectnow.com. Any of the resources that I'm talking about or that anybody else talks about in this presentation are found on guardianconnectnow.com. We also have a private Facebook group, which has, I think, just about 300 people in it now. And this is also for caregivers in Nebraska. So guardians, conservators, powers of attorney, anybody who touches anybody in terms of providing support. So if you're providing care, support, if you're a professional in either of those roles, helping clients, the private Facebook group is definitely for you. It is very much like the weekly clinic, except that it's not live, and you can post questions, share resources, and honestly, it's also a place to put some praise. So if you've had a really cool thing happen to you, or you want to show off something that someone did, like I recently shared a success story that my ward, Charlie, became president of the Residents Council at his assisted living facility. So it's also a place to show wins. We hope that you join. If you go to guardianconnectnow.com and you are a Facebook user, you can find a link to join that group. We will let you in, and we would love, love, love to have you there. Also on the Guardian Connect Now website, we have workshops and replays. So at this point, we have probably done a workshop on any topic and every topic that a guardian could care about. If you go to guardianconnectnow.com, you can access a lot of those main workshops, which cover annual reporting, questions about guardianship, differences between a power of attorney and a guardian. Lots and lots of topics are covered there. And so you can definitely watch those on your own time. They're replays of workshops much like this, like what we're doing right now. We also have some master classes on our guardianconnectnow.com platform, and those are special interest topics for guardians. Like, for example, how to sign a contract to make sure that you don't have personal liability. Those are also available on that particular website. Also, we have a really cool thing where we partnered with the Volunteer Lawyer Project in Nebraska to provide pro bono services for families across the state that can't access a traditional client relationship with an attorney, but their loved one might need a guardianship. And so we have created this DIY guide, which gives people fillable forms and instructions on how to fill them out so that they can navigate their own guardianship journey. That's available if you qualify for free services through the Volunteer Lawyer Project, but we also offer it at a very, very affordable rate in our office in order to allow access to families who don't qualify for free services, but also aren't interested in a traditional attorney-client relationship. So that's available on the Guardian Connect Now platform as well. It has its own page. You can watch videos about that if that's something that you want to explore. And then lastly, on the platform, we've got free PDFs that you can download. One of the ones that's really cool is a checklist for your annual reporting. If you are a guardian or you've talked to a lawyer about becoming a guardian, you're probably aware of the annual reporting requirement. It's the thing that is most complained about in guardianship and conservatorship. And so we have a checklist there for you on how to complete that on your own. And actually, some of the workshops that are available on the page are master classes on how to complete your annual report. So it's robust. It's a treasure trove of things. Check out guardianconnectnow.com. All right. We want this presentation to be interactive. And so we all have our chat boxes open. If you have questions, we want you to put them in the chat. We'll pause and tackle things as we're going along. If you are watching the replay of this, it is going to be on social media. So put your questions in the comments below. Somebody will circle back and be able to answer for you. If you are watching this on the DSAF page, still put your comments. I'll monitor those and make sure that we get those answered to the best of our ability. So just know that our goal is that you get your questions answered and that this information is valuable to you. As I mentioned at the beginning, this is the first of 3 presentations, and what we're focused on is time horizons. And for this presentation, we're focused on time horizons between birth and age 18. Now, if you're a parent who has not done something by a time horizon that we talk about, we do not want you to panic. That is not the purpose of this presentation. You are not too late. The things that happen in the lifetime of your special needs child are constantly reviewed. You are not left behind. It is okay. So we don't want anybody to cause um, we don't want to cause anybody concern after seeing this presentation. So you're right on time. You're here today. Congratulations for being here today. And we're going to kick things off and actually start talking about what you want to know, which is birth to age 18 as a special needs parent. The first event in this time horizon from birth to age 18 is obviously the diagnosis. And so we're talking about a diagnosis of a developmental disability. This can be physical, this can be intellectual, it can be both. And don't be misled because sometimes the diagnosis doesn't come until way later in your child's life. In fact, there is an individual, a mom I know, whose child was not diagnosed with a developmental disability until days before their graduation. But the important takeaway is that we're really starting the clock from diagnosis forward. And the way that we have styled this presentation is to talk to you really about the things that we would do either as parents of special needs kids or if we were parents of special needs kids. And the very first thing that we would do from diagnosis on is ask who's going to take care of my special needs child. And Eric is going to talk to you about this particular question.
Yeah. So when you find out a diagnosis, that's saying that your child is disabled physically, mentally, et cetera, we kind of go through some of the basics of who, what, and how. And the first who question is really about who's going to take care of your child. And there's a couple ways that you can do this. You could do nothing, and that's an option, but it's not always the best way to do things. If you do nothing, then that decision is going to have to go through court. You're going to have to, have people petition or, hope that somebody's going to step up. What's a better option is instead to go ahead and have discussions with the people around you. So, discussions with family, discussions with caretakers, discussions with the parties involved that you trust, that you think would do a good job with this. And then you can nominate them. And nominating them is a part of your estate plan. And so you, as the parent or the guardian of the child, you would go ahead and nominate somebody to step up once you are deceased or when you're incapable of being able to care for them. You could do that in a couple forms. So the main way that we do this is through wills. We also do this through trusts. We do this very often in trusts because we also, which I'll talk about a little bit later, but we also talk about special needs trusts. And so it really makes sense sometimes to kind of have those pieces go hand in hand. If you're going to have assets that are going to go to a minor who does have these disabilities, it makes sense to kind of coordinate those pieces together of who's going to serve and who's going to serve in this trust role of handling finances for that child. So it's all about nominating. I mentioned, you might be a relative. That's very common. It could be a friend, somebody trusted. And as I mentioned as well, if you already are a guardian, it also could look like nominating a successor. Or, if you're not a guardian, you might nominate your first person who would take care, who would be a guardian for your child. And then you would also nominate a successor. And I've had clients who, they say, I want to nominate several people because I want to be prepared for every situation, And so I've had people that will name 5, 6 names. I don't think that's really necessary for most people, but your plan is your plan. And so if that's what you feel like you need to do, you do that. For most people, you name kind of your primary person, a secondary, and the goal is just to kind of have your bases covered. So the next thing we'll talk about is what will happen. And that what question really is about how that person, not how that person, but what will they do to take care of that? And I think we do have a question here, so I can pause before we get to what. Somebody asked, what's the main difference between a will and a trust when we're talking about contingency planning? I can talk just briefly to the will and trust distinction. It's really a difference of styling, of ability to be kind of prescriptive and detailed. So your will document and a will-based plan is going to be your primary vessel for um, telling people how your assets are going to be divvied up when you do pass away. Um, Whereas in the trust document, that trust document does that. And the trust document just inherently has a little bit more ability to be customized. And it also has the ability to maybe deal with a broader range of situations. It also comes with more privacy. And I say that because in Nebraska, at least, when we do pass away, if we have a will, that will does get probated. And when a will is probated, the original gets given to the court, and then a copy of it goes on the online record or in the file. And so somebody that, an attorney or somebody who wanted to look up a case could go in there, look at the will, could see the assets, the total assets that you had, and if you disinherited your child Joey, they're going to see that you disinherited your child Joey, right? Versus in a trust document that doesn't get filed with the and so you maintain that privacy of, you get to give items to your church or to, your children, or you get to disinherit, or you can customize it with that privacy. And the other big thing that people really like about trusts is you often hear the term probate, which is just the court where you go through to have your will kind of approved and to appoint a personal representative and executor of your estate. Your will document will nominate somebody, or your trust document will nominate somebody, but if you want to avoid probate, quote unquote, the trust document can be used for that. And essentially what that looks like is you just set up your planning in such a way that all of the items are already kind of designated to go to somebody. And so there is no estate then that has to go through the court. You still have to do an inheritance tax. And so you have to do an inventory and inheritance tax regardless. But you don't have to then deal with submitting the will, doing all these pieces to that. So that's kind of one of the main ways that trust can also be used that wills really can't. So getting back to that what question. So what will they take care of my special needs child with if something happens to me? And so it's really a funding question. Practically, when you pass away, if you have a child that has these needs, they might have expenses that are kind of beyond what a normal, quote unquote, normal child would have, right? And that might look like physical needs. That might look like, getting a high quality wheelchair, or getting kind of extra training or education, or things like that. And so if you have the means and if you have the ability to kind of plan for that, you can do that through some tools. The main tool we talk about is called a special needs trust. And the special needs trust is a really cool tool because it places the ability to make decisions in your hands as parent. And I say make decisions in the sense of the money that you put into it, you can direct. And so you can say that, yes, this is going to go to my child for their needs. It will cover all the things that government benefits won't cover. And most importantly, it maintains eligibility for benefits. So, if and when that person is on government benefits, if they were to be over-resourced because of all this money, the special needs trust is basically ignored by the state. And so the money that's in there doesn't count for that resource limit. And so you could have a child who has $50,000, $100,000, more than that, and they're still eligible for government benefits because the money's in a special needs trust. That special needs trust can come in different ways. And so it could be part of a will. It could also be a standalone document, and it could also just be kind of built into your trust in your plan. And what that looks like is if you had a trust document, it would say something to the tune of, if I have a child who has special needs when I pass away, I want their share to go into this special needs trust. It will be used for X, Y, and Z, which is, all of the extras in life that government benefits won't cover. And that's kind of a nice piece because it's integrated then into your trust document. From there, we talk about how do you fund it, and that usually could look like life insurance. That's a really good way to do it because um, you may never, have that funding issue, so long as you're alive. But when you do pass, it can be hard to, if you don't have a huge estate already, to chunk up a huge piece or to know exactly, how much that child might need moving onward. And so life insurance can be a really good way to do that. And you can do some of that projected spending, the annual costs that you have and that you think you're going to have until age 18. We also had a question about, so who would serve? And I think that's our next, or no, that was our slide back. So I'll go back one. So how do we decide who should take care of the special needs child? Um, you know, it often is a personal decision, but it always should be somebody that you trust. And oftentimes that means that it's somebody who has particular either experience or knowledge of you, of your child. Um, maybe it's somebody that has a good background in nursing in your family, for example, or maybe it's just um, a child of yours that's an adult that you think would do a good job, or a sibling, or someone like that, or it's a friend that you've known for quite some time. And those are kind of the main ways that we make those decisions. I'm having some more questions come in, so I will answer these as they're coming in. Next we had, does the person who manages the trust have to be the same person as the caregiver if something happens to you as the parent? No, they don't have to be the same person. Sometimes it makes sense to have the same person in the same roles. And so for a trust, the person that handles the trust, which is mostly about finances, is called the trustee. While you're alive, you're the trustee of your own trust typically. And so it might make sense then to have somebody be in charge of the finances of your child, who also would then be the trustee of your trust, right? But in terms of like physical decision making, in terms of like housing and getting them to appointments and stuff like that, it doesn't have to be the same person. And technically, it doesn't have to be the same person for the trust or a financial, like a rep payee or somebody who's handling finances. But it does make a lot of sense, I think, just practically to make that the same. We had a question about what qualifies as a special need. That's a great question, and it's a little bit gray, though typically, we're talking about special needs. It's going to be some kind of diagnosis that would then qualify somebody for benefits, or just practically means that they need help, in everyday living. So whether that looks like decision making about contracting, like if they're not able to make a decision about a contract, if they're not able to make decisions about their housing, stuff like that. And some of that's inherent in being a minor, but typically that looks like something more than your quote unquote typical child who has no diagnoses. And I do think there's some gray area here. Oftentimes we hear about people who have children with ADHD. And ADHD is a real spectrum in the sense that you might have somebody whose child has ADHD, but is so incredibly high functioning that you would never know. They have no behavioral, issues that accompany it. At least nothing, that's hampering their quality of life, right? And so there is some gray area here. For this context, the Down Syndrome Alliance, oftentimes we will have high functioning people with Down syndrome or low functioning people. But regardless, those kind of special needs are the kind that would qualify, and it would make sense to do this kind of special needs planning for, because you do want to maintain benefit eligibility through Medicaid. You do want to be able to provide for them and still make sure they're eligible, and that your planning for them will be able to be passed on to your other children or to another beneficiary when they were to pass away. We had a question. I had said during the trust piece, does XYZ have to be specific or can it be vague, like for living expenses? So I think that was in the context of special needs trusts. And special needs trusts really are to cover those needs that are beyond what government benefits will cover. And that can look like living expenses. The examples we give are often about, kind of what's something above and beyond what government benefits would cover. And so maybe that's furniture for this person's room. Maybe that's um, an extra nice piece of technology. Maybe it's a computer or a tablet, or and maybe it's educational services that aren't going to be covered. Um, and so we kind of specify some of those things in the trust document, but typically just the broad language is it something beyond what government benefits will cover? If so, that's really what the trust, especially these trust funds, should be used for. Okay. Another question. Do you think it's important to choose somebody with disability knowledge, or are there ways to dictate additional disability care assistance if the individual you choose doesn't fully understand that disability? That's a great question. And I think it really ties into my next slide of how. I apologize, I get parched here from talking. So how will they be able to take care of my special needs child if something does happen to you? Um, the main way we do this is through this letter of instruction. And um, it can sound like a big thing. It can be a big thing, but practically it doesn't have to be something scary. My apologies. So that letter of instruction really is a piece that is helpful because it's really just about your child. So that might look like, what's something that I know about my child that other people wouldn't know? What kind of behavior plans do we have that, help them achieve their best, and productive life, right? What are some dietary restrictions they might have? What are some educational goals that I have for my child? What are some travel goals? Or, do I want them to live in Nebraska? Do I want them to never live in Iowa if I'm a big anti-Iowa person, right? Don't let Phil hear that. But that might be your opinion, right? So it really is about those specific things that are both your goals, but also about your child's needs. And you're kind of just writing all those down and telling this person, hey, these are all the things that you need to know about my child, about their needs, about how we handle those, and about the goals that we have. And some of that might be about even just providing some of the information about, hey, but our goal is to get them onto benefits. Our goal is to have a service coordinator. Um, our goal is that we don't want them to be in an institutionalized setting or in some kind of shared, maybe I want them to be in a shared living provider setting. Maybe I want, so it's all of those pieces. We talk about care needs and expectations, right? Um, and the way that we kind of give that information is personalized, and it's also just really meant to help that person. Like that question we had about, if you have to choose somebody that knows all these things about disability, you can. It might be really helpful, but it also, you don't really need to because, the goal is that this and the rest of your planning should be able to inform that person. So that way they can at least get, as close to up to speed as what you as parent know. Um, I had another question about how to vet trustees. Um, trustees, it really should just be about somebody that you trust. And oftentimes, the initial trustees typically will be yourself. And then oftentimes if you're married or in like a long-term, trusted relationship, it could be your partner. It could look like adult siblings or other adult children that you have that you think are going to be responsible and would make sure that your child gets access to the funds for the things that they need. Sometimes I recommend that you have sort of a backup too. So you could nominate some kind of corporate fiduciary as your last resort as well. But yeah, it's typically just about people that you trust that would be able to make sure that when your child has those needs or has those opportunities, that they're getting those funds that for costs that aren't going to be covered by benefits. And the other thing I had here was any best practices for checks and balances for trustees in a will and trust. In other words, having two people in those roles. It's really a school of thought question, I guess, because, I have heard some people from time to time say that they would like to have a check and a balance, a trustee, um, in one role and then maybe a different rep payee or something like that. Or a trustee and then a different guardian or uh, stuff like that. It's really a preference. Like you can do it that way if you have concerns that maybe one person would have too much power or might not act in the best interest. But I guess my pushback would be if you have concerns that the person's not going to act in your child's best interest, maybe they shouldn't be nominated as a guardian or as a trustee, right? So that's part of this vetting process is um, just your relationships and your knowledge of how they have acted, up to this point. Have they been trustworthy in handling finances? Have they been responsible and respectful around your child? And all those things. It's very personal, but all those things go into that decision. And so typically, I don't recommend having separate people to do these different roles because it's a lot simpler when you have one person who can handle the finances all the way through. But again, it's a personalized plan, and so that decision is really up to each adult, to each parent um, as they make them. Another question: if we should be revisiting or updating the estate plan regularly, and how often do we recommend that? Um, I always say like life events, like big life events. So for me, I should be updating my estate plan now. I have a child. So births, marriages, deaths, um, divorces, all of those big life events where your family is changing in some way, or, um, you know, heaven forbid, but if you were to have, a large falling out with family that you were going to inherit, especially children, um, you know, that might also be an event where you say, okay, I need to disinherit this child. That's not typically something that I'm really happy about, but certain situations dictate that. And so it's all about life events. So births, deaths, marriages, etc. Um, and also just, there's a certain regularity to it. If it's been 10, 15, 20 years, even 5 years for some people, um, or let's say your child now becomes an adult, that also might be like a good life event to where you say, okay, now I can update and I want my child to now be involved in my estate plan in some way, whether that be as a personal representative or a financial power of attorney or healthcare, right? All those things. And when I say child, I mean typically a non-disabled child, though there is a gray area there too, right? If you have a really high functioning child with autism, maybe they could be able to handle some of those healthcare decisions or something like that. So it's always good to just check in on those events. One more I had was if you have a trust and your parents die, are you checking up to make sure the trust is carried out or who does that? So, it's really the trustee that's going to be in charge of this. And so usually that's the person that made the trust. So if your parents made the trust, they pass away, then whoever's nominated as kind of the successor trustee would be the person to step up. And that's also why I tell people it's important to let your children know and maybe consult with them about who's going to be next in line. And so they're going to kind of step into that role. They'll work with the bank. They'll work on, if distribution needs to happen, they'll go ahead and do that. Or if the trust needs to be continued, they'll do that as well. So I think I got all the questions here, but I'm sure we'll get more as we keep going.
Okay, so thank you for that, Eric. And after we get past the initial diagnosis and the concerns or the issues that every special needs parent really needs to address up front, we need to look towards the next time horizon, which is usually around age 17. Now, this is not necessarily going to be true for every family. Remember, every situation is unique. Every family is unique. There are going to be exceptions to what I'm saying, but generally speaking, age 17 is really the time in your child's life when you need to start deciding what their future looks like in terms of what support they're going to need. And age 17 is important because Nebraska throws a wrench in our decision-making process by having a different age of majority than the federal government. And this is important for the benefits that we're going to talk about in an upcoming slide. When we talk about supports, whether or not it's in a guardianship context, it's in a power of attorney context, it's in an informal context, we're usually talking about two main areas. And the first area is medical, and the second area is financial. Usually, you can trace back any decision that you have to make as an adult to one of those two things, medical or financial, at least for which you might need a decision maker appointed for you. I'm not talking about the day-to-day decisions like what do you wear or what do you eat for dinner. We're talking about the kinds of decisions where if you can't make them on your own, you might need someone to either help you or make them for you. And so medical and financial are the two big arenas that we're talking about when we're assessing this. So when your special needs child is approaching age 17, this is the thought process or the discussion that you should be having with the rest of your family. What does their life look like when they're an adult? Can they make their own medical decisions? And if they can make their own medical decisions, is there a kind of medical decision that maybe would be too complex for them to understand? Because I think in most situations, even kiddos who approach age 19 and get a guardian appointed for them probably could make and communicate some responsible decisions about medical decisions. A great example of this is being asked if you want a flu shot. Now, again, this doesn't apply to everybody. Someone may be nonverbal and this wouldn't apply to them, but in a lot of situations, I think even people who would say that an individual needs a guardian probably could assess whether or not they wanted a flu shot. I know that a lot of my wards can. But if you asked them, graduated medical decisions beyond that, like surgery or maybe something that was a trial, an experimental drug, they would not be able to appreciate the risks and benefits. And so, really assessing what kind of support someone needs, if they even need support at all, is really important for the next conversations you have to be discussing with your friends, your family, other professionals in your life, your attorney, to make sure that you are providing what's necessary for your situation. The first thing that every parent should think about, which is often never talked about, in fact, if you've ever talked to an attorney, even one who says that they do guardianship and conservatorship, I would bet you they never talk to you about informal supports. And this is something that is just ignored and leaped over when we're in the guardianship world. But we want to talk about informal supports because if there are informal supports that will provide your child the help they need in a particular area where they might need support, we don't need to have a guardianship. We may not even need to have a power of attorney. And so informal supports are often overlooked because it seems too easy or it's too generalized, but it could be as simple as, if your child needs transportation to the bank to cash a check and transportation is the only part of that equation that they can't do on their own, that's not a basis for a guardianship. So it's really assessing what's going on in their life, maybe what the next 5 to 7 years looks like for them, and whether or not formal help is needed for the certain arenas in their life. Now, informal is something that's ideal. If we can't get informal help, then we want to look to formal help. And formal help would be like a payee, a power of attorney, or a guardianship like we have been talking about. Phil's going to talk to you now a little bit about the differences between a payee and a power of attorney.
Okay, so when we talk about a payee, what we're talking about is a representative payee. The Social Security Administration allows for someone to be the representative payee for someone who is receiving benefits. The way that looks at current is you schedule a time and you go and have an in-person interview at the Social Security Administration. You talk about what your relationship is with the individual who is on benefits and what your plan is to sort of guide those benefits, make sure that the benefits that the person is being paid can be used for their benefit, for their care, for their support, right? And then power of attorney, most places talk typically about just the first two there. Oops, we have a typo. Medical or financial powers of attorney. medical power of attorney is so someone can be there with you at your medical visits and have an opinion, be able to help you make decisions about your treatment, advocate for your care, but it doesn't eliminate the ability for you to make decisions on your own. Financial power of attorney. Financial power of attorney, also referred to typically as a durable power of attorney, that is so that someone can be able to help with bank accounts, help with spending patterns, make sure that bills are paid on time, make sure that contracts, like complex contracts, can be interpreted and sort of distilled for the person who has that power of attorney. What's really unique about our practice, what's really unique about us here at Blazek Law Group is that we had, Molly and Eric took the time to create what's called a special needs power of attorney that functions fairly similarly to kind of what I would call like a guardianship light. The person still has the ability to make decisions on their own, but they have somebody who's there to help them do it. If your ward is someone who can be trusted to make day-to-day tasks on what they eat, what they wear, how they get places, but perhaps they just need somebody to help them navigate that, distill information, help discuss what their options are so that they have a complete understanding of what's going on before they move forward, then a special needs power of attorney makes sense, right? If it's someone who's incapable of making decisions on their own, then we're no longer looking at the area of a power of attorney. If someone can't be trusted to reliably make decisions that would benefit themselves, or they're incapable of seeing the benefit long term to some decisions, like every day the only thing that they're willing to eat is ice cream. We need some variability in our diet. We need something to make things go a little, and these are sort of silly examples, but it can get really extreme. It can get really scary if someone, like in the case of one of our clients, refuses to eat, continues to refuse to eat, continues to refuse to make decisions that would help them become healthy, allow them independence. Sometimes you need something more than a power of attorney. Sometimes you need the full weight and effect of the court in order to get someone to the point where they can see how to take care of themselves again. But a special needs power of attorney is sort of like that middle area where you can help someone advocate for themselves. But since the power from a power of attorney comes from the individual themselves, they still have independence. They still have the ability to make some of those decisions on their own, but it's not fully, it's not fully sort of taken away from them. They can make some decisions, but also they have somebody there to support them and prop them up when they need that little extra push.
Yes, thank you for that, Phil. And I think the value between the last slide and this slide are not so much in having enough information presented so that you could make a decision about what your special needs child might need for support. It's more about realizing that guardianship is not a one-size-fits-all thing, and it's not the only answer. And actually, our legal community and our society really as a whole has been conditioned with this idea that guardianship is the one and only answer for special needs kids. And that's just simply not true. We can look to other states to show this for guidance, because one of the things that I really wish Nebraska would adopt is what's called supportive decision making. This is something that's making waves in other states, and it is something that allows a special needs individual the ability to make the decisions that they can make on their own, and then they get to decide who helps them make decisions for those things that they can't. And one of the really, really cool things about supported decision making is that this idea is a concept that abled adults get to utilize every day of their life. Like if you're similar to me, you don't do your own taxes. I get to select a CPA from the community who I trust, who I have, a relationship with, and they help me complete my taxes. I don't complete my taxes on my own. That idea is very similar in supported decision making, where a special needs individual would say, I might need some help making advanced financial decisions. I can't count money, so I need somebody else to manage that for me. But I want to pick who's going to help me with that. I don't want a court to decide who's going to help me with that. I want to pick who's going to help me with that. And so it's a model of what you and I are doing every single day, and allowing a special needs individual that same autonomy, that same dignity, that same independence that you and I get. Now, as I mentioned, Nebraska doesn't have this. And so one of the beautiful things about a special needs power of attorney is that it provides this opportunity without the act actually being available in Nebraska. So as Phil was saying, it allows exactly that independence, that dignity, that autonomy, but it also provides that safety layer of support for advanced decisions. And the beautiful thing is that you don't have a court coming into your life saying, yeah, this is the person who's going to make decisions for you until I say differently. It allows the special needs individual to identify the supports that they want. And that's just something that's totally ignored. It's just not discussed. Really, I think by a lot of professionals. If you're like our clients, they come into our office and they say, well, I'm here because somebody at the IEP said I needed guardianship for my child, or my pediatrician said I needed guardianship for my child. Now, there's no way for us to be able to give you enough information so that you can make that decision here today. That's not the point of our presentation. The point of our presentation is you have far more options than that. Your goal is to connect with a legal advisor who's going to talk to you about all the options and create a customized plan specific for your special needs child, which may or may not include guardianship. After you kind of plan that out with an attorney of your choosing, the next time horizon is age 18. And we're getting to the end of our hour. So I'm going to talk briefly about some important things, and then we can end here and you can let us know if we have any questions. But at age 18, that's when you need to start applying for Social Security benefits. And for a special needs individual, that's going to be SSI, which is Supplemental Security Income. Now, a tip for parents when they're applying at age 18 for this is making sure you identify a room and board amount. This is very important so that your child gets the full benefit. A lot of parents will be asked through this application process whether they're charging their child for them to live in the family home. And most parents are saying, no, 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 I'm not going to charge my child, because they inherently think that that's bad. But that's actually not what you should be saying, because at age 18, the federal government considers your child an adult. Nebraska doesn't. Nebraska is age 19, and this is where Nebraska kind of throws a wrench in all of this. But at age 18, as far as Social Security is concerned, your child is an adult and they would be living independently outside of your home. It's a strange mental shift to make, but you really have to start thinking of your child in terms of a roommate. So when you apply for SSI, you have to designate an amount that it would cost for them to live in your home. So it'd be reimbursement to you for whatever your expenses are in housing and food for them to be there. So just be aware that the answer is not, I'm not charging. That would be a bad answer. And you can talk to an attorney or other parents who have been through the process for more advice on that. But room and board is a big thing, and it's a big shift for parents. So I want to make note of that before we run out of time. The second thing is, when you become eligible for SSI in Nebraska, and if I didn't say it before, when I say at age 18, I mean literally on the birthday. So like on your child's 18th birthday, that's when you need to apply for SSI. In Nebraska, when you become eligible for SSI, you are also dual eligible for Medicaid. Now, you still have to apply for Medicaid, but you become eligible based on SSI approving your application based on a disability. So you'll want to apply for Medicaid The different types of Medicaid waivers that are available to you could be an entirely different program. But make sure that you're applying for Medicaid in addition to SSI. Some states, when you're approved for SSI, you're automatically enrolled in Medicaid. That's not true in Nebraska. So you have to apply. You are eligible, but you still have to go through that application process. And again, the type of Medicaid is going to depend on the needs of your child. So I think that's all that I've got time for here, because we're really at the end of the hour. But I want to encourage each attendee or anybody watching the replay, go to those resources that we shared at the very beginning of the presentation. Join our Facebook group. Put your questions in the comments below. If you're watching this on a social media post, we love to talk guardianship, conservatorship, and special needs at Blazek Law Group. So we will try to answer your questions. You're always welcome to join a clinic on Thursday and ask us your questions for free. This is really our passion. We love the work that we get to do. And thank you so much for giving us an hour today.